It's a routine traffic stop on a Florida roadway. Flashing lights, a driver pulled to the shoulder, a citation printed and placed on the hood of a patrol car. The officer asks for a signature, not as an admission of guilt, but as a promise to appear. She refuses. Seconds later, she's placed in handcuffs. But here's the real question. Under Florida law, can refusing to sign a traffic citation legally lead to arrest? Or did this encounter cross a constitutional boundary? Let me know what you think in the comments below. According to Florida statutory law and long-standing traffic enforcement procedures, when a law enforcement officer issues most non-criminal traffic citations, the driver is typically required to sign the citation. The signature does not constitute an admission of guilt. Instead, it serves as a written promise to appear in court or otherwise respond to the citation. This process is governed primarily by Florida Statutes, Section 318.14, which outlines the procedure for handling traffic infractions. Under Section 318.14(2), any person cited for a violation of Chapter 316, Florida's Uniform Traffic Control Law, must sign and accept a citation indicating a promise to appear. The statute further provides that a person who refuses to sign the citation may be arrested. This provision has been part of Florida's traffic enforcement framework for decades and has been upheld as constitutionally permissible under the state's authority to regulate roadway safety. In many recorded encounters across Florida, disputes arise not over the alleged traffic violation itself, but over the requirement to sign the ticket. Drivers sometimes state that they do not consent, that they do not contract, or that signing would be an admission of guilt. However, Florida courts have consistently interpreted the signature requirement as procedural rather than punitive. The Florida Supreme Court has explained in past opinions addressing traffic enforcement authority that traffic stops constitute seizures under the Fourth Amendment, but are permissible when supported by probable cause or reasonable suspicion of a traffic violation. Once a lawful stop occurs, officers may issue citations in lieu of custodial arrest for qualifying infractions. The citation process is designed to reduce unnecessary jail bookings while still compelling court appearance. According to official guidance published by several Florida sheriff's offices, refusal to sign a citation transforms what would otherwise be a non-custodial encounter into a custodial situation because the officer must ensure the driver's appearance in court. In that context, the arrest is not for the traffic infraction itself, but for failure to comply with the statutory citation procedure. Civil liberties advocates, however, have raised concerns about escalation during traffic stops. One perspective is that while the statute permits arrest upon refusal to sign, officers retain discretion. Another perspective is that once refusal occurs, the statutory language, "shall be arrested," removes discretion and mandates custodial action. To understand whether an arrest in such a scenario is lawful, several constitutional principles come into play. The Fourth Amendment to the United States Constitution protects against unreasonable searches and seizures. A traffic stop is considered a seizure. The U.S. Supreme Court, in cases such as Atwater v. City of Lago Vista, held that an officer may arrest an individual for even a minor criminal offense committed in the officer's presence, including misdemeanors punishable only by fine, without violating the Fourth Amendment. Although Atwater involved Texas law and a seatbelt violation, its holding applies broadly. The court reasoned that when probable cause exists, custodial arrest for a fine-only offense does not automatically violate the Constitution. This precedent significantly shapes how courts evaluate traffic-related arrests nationwide, including in Florida. In Florida specifically, courts have examined arrests stemming from refusal to sign citations. Appellate decisions have generally upheld such arrests when officers complied with statutory procedures and the initial stop was lawful. The reasoning typically focuses on the statutory requirement and the government's legitimate interest in ensuring court compliance. However, the analysis does not end there. Even when an arrest is statutorily authorized, courts may still examine whether excessive force was used during the arrest. The U.S. Supreme Court's decision in Graham v. Connor established that claims of excessive force during an arrest are evaluated under an objective reasonableness standard. This means courts consider whether the officer's actions were reasonable from the perspective of a reasonable officer on the scene, rather than with hindsight. In many viral Florida traffic stop videos, disputes arise not only about the legality of arrest for refusal to sign, but about how quickly officers move to physical restraint. Some drivers argue that they were not adequately informed that refusal would result in arrest. Others claim they were confused about the purpose of the signature. From a legal standpoint, courts generally assess whether the officer provided clear instructions and whether the refusal was unequivocal. If a driver explicitly states they will not sign, and the statute requires signature, the officer's authority to arrest is typically upheld. One interpretation is that the law provides clarity: sign the citation and contest it in court later. Another interpretation is that escalation could sometimes be avoided through additional explanation or de-escalation techniques. This distinction matters because federal civil rights lawsuits under 42 U.S.C. Par. 1983 often hinge not just on whether an arrest was technically permitted, but whether constitutional rights were violated during the process. Plaintiffs in such cases may allege unlawful arrest, excessive force, or retaliation. Defendants often raise qualified immunity, a doctrine that shields officers from liability unless they violated clearly established constitutional rights. In reviewing similar Florida cases, federal courts have frequently granted qualified immunity where the statutory authority to arrest for refusal to sign was clearly established. The reasoning is that when state law explicitly authorizes arrest under defined circumstances, officers are generally entitled to rely on that authority. Still, each case turns on specific facts. Was the original stop supported by probable cause? Was the driver clearly instructed to sign? Was the driver given a meaningful opportunity to comply? Were the handcuffs applied in a reasonable manner? Was any force beyond routine handcuffing used? Body-worn camera footage often becomes central evidence. Courts review whether the footage contradicts or supports allegations. In Scott v. Harris, the U.S. Supreme Court held that when video evidence clearly contradicts one party's version of events, courts should view the facts in the light depicted by the video. Florida's public records law, one of the broadest in the nation, often allows such footage to be released after investigations conclude. This transparency can clarify disputes about tone, timing, and physical actions. Another important factor involves the Fifth Amendment. Some drivers argue that signing a citation violates their right against self-incrimination. However, courts have consistently held that a citation signature acknowledging receipt and promise to appear does not constitute testimonial admission of guilt. Similarly, arguments rooted in contract law, such as claims that signing creates a binding contract, have not found support in Florida appellate decisions regarding traffic enforcement. Law enforcement agencies in Florida typically train officers that they must explain the purpose of the signature. Standard phrasing often includes statements such as, "Your signature is not an admission of guilt. It is simply a promise to appear." If an officer fails to provide that clarification, a defense attorney might argue procedural deficiency. However, even then, courts may examine whether the driver nonetheless understood the requirement. It is also important to distinguish between civil infractions and criminal offenses. Many routine traffic violations in Florida are non-criminal infractions handled through civil penalties. Refusal to sign, however, can elevate the situation into a criminal matter because it constitutes failure to comply with statutory procedure. Critics argue that this framework can create sudden escalation in otherwise minor encounters. Supporters argue that without enforcement authority, drivers could ignore citations without consequence. The policy rationale behind requiring signature is administrative efficiency. It allows officers to avoid taking drivers into custody for minor violations, saving time and resources. The trade-off is that refusal removes that streamlined alternative. In evaluating whether seconds later she's in handcuffs is lawful, timing alone does not determine legality. The key legal question is whether statutory conditions for arrest were satisfied at that moment. Courts often analyze whether the refusal was clear and final. If a driver hesitates or asks questions, that may not constitute refusal. If a driver explicitly states, "I will not sign," after explanation, courts typically consider that refusal. Another layer involves potential First Amendment claims. Some drivers record traffic stops. Recording police in public is generally protected under the First Amendment, subject to reasonable time, place, and manner restrictions. However, refusal to sign a citation is legally distinct from recording activity. If an arrest occurs solely because a person is recording, courts scrutinize potential retaliation. But when the arrest is based on refusal to sign under statutory authority, retaliation claims are more difficult to sustain unless evidence shows pretext. The broader constitutional balance involves state authority to regulate roadway safety versus individual liberty interests. The Supreme Court has long recognized the government's strong interest in traffic regulation, given the risks inherent in motor vehicle operation. At the same time, constitutional protections do not disappear during traffic stops. Drivers retain rights against unreasonable searches, prolonged detention without justification, and excessive force. In practical terms, many defense attorneys advise clients that signing a citation is typically the fastest way to conclude a stop and challenge the allegation later in court. Refusal rarely eliminates the citation. It often results in additional charges or arrest. From the officer's perspective, once refusal occurs, failure to act could undermine statutory enforcement. From the driver's perspective, sudden handcuffing can feel disproportionate to the initial infraction. Courts reviewing such incidents focus on objective reasonableness rather than emotional reaction. The analysis centers on what a reasonable officer would do under similar circumstances. In federal civil litigation arising from Florida traffic stops involving refusal to sign, plaintiffs must show that no reasonable officer could have believed the arrest was lawful. Given the explicit statutory language, that burden is often high. However, if additional factors are present, such as unnecessary force, prolonged detention beyond processing needs, or separate constitutional violations, courts may allow claims to proceed. Ultimately, the legality of arrest for refusing to sign a Florida traffic citation rests on three primary pillars: the validity of the initial stop, the clarity of the refusal, and compliance with statutory procedure. This discussion is for informational purposes only, and not legal advice. Encounters like these raise broader questions about communication, discretion, and constitutional boundaries during everyday law enforcement interactions. Florida law provides officers authority to arrest upon refusal to sign a citation. Federal precedent allows custodial arrest for fine-only offenses when supported by probable cause. At the same time, constitutional safeguards require that force be reasonable and that stops not exceed lawful scope. So when you see a headline stating that someone refused to sign a ticket and was in handcuffs seconds later, the legal answer is rarely found in the headline alone. It lies in the statutory framework, the constitutional standards, and the specific facts captured on record. Given the legal structure we've discussed, do you believe arrest in this situation reflects appropriate enforcement of Florida law, or does it suggest that traffic stop procedures need reform? Share your thoughts in the comments below, and if you'd like more in-depth breakdowns of real legal scenarios, consider subscribing for future analyses.